Good afternoon. I hope that this is working correctly. Please let me know if it's not. My name is Chris DiOrio, and I've posted a lot on Facebook about a lot of things related to the law and civil rights, etc. I am a civil rights advocate and professor, as well as an attorney. And so when people when I write things, they tend to go on too long, and they don't read them. So I've had people suggest to me that perhaps it might be better for me to do little video chats of things. So that's what we're going to try to do. I understand that based on the most recent elections and with situations that happened beforehand, it's better to sometimes get a sense as to what your rights are. There have been a lot of protests after the election on both sides of things, and I want to help you understand what your individual rights are, your civil rights in terms of protesting and demonstrating, so that you don't get yourselves in trouble and that you are doing something safely and securely, and acting within your individual rights as an American citizen. First, the genesis of all of this comes from the First Amendment. Right there at the end of the First Amendment, it refers to, after it goes through all of the freedom of the speech and the press and things of that nature, it says that you have the right, that the people have the right to peaceably assemble and to petition the government for a redress of grievances. Now, the key word there, when you're dealing with the right to assemble, and you have that right to assemble, is the right to peaceably assemble. And this is where people run into problems. As soon as you tread over into an area where law enforcement can look to what you are doing and say that this is no longer peaceful, at that point you cross the line, potentially, in terms of being prosecuted for things that may infringe upon your rights, but at that point you are at the whim of the police officer. So peaceably assemble is the key. First, they cannot restrict what you say. Even if what you are going to say is controversial, even if it's way out there, the First Amendment prohibits the government from restricting your content of speech. This doesn't mean that everything is protected. You can't openly threaten people. You can't yell fire in a crowded theater. And in terms of a demonstration, you can peaceably say things, but you cannot advocate violence, because this is, again, where you cross the line. The police and the government are allowed to place certain restrictions on your demonstration. They're what are known as time, place, and manner restrictions. They cannot be discriminatory, however. And that's a key. That's a problem. If they're going to restrict your ability to demonstrate because of what you are demonstrating about, then that is unconstitutional. It has to be a non-discriminatory, narrowly drawn restriction on your First Amendment right to demonstrate. Anything that they do has to apply to all speech, not just the speech that you're talking about. Where exactly can you demonstrate? Anywhere in public. The language that most court cases will use is they will say that your speech is constitutionally protected in what are known as traditional public forums. What that means is streets, sidewalks, public parks. You can do things in public locations that the government would normally open up for these types of events, such as the plaza in front of a government building, the area in front of City Hall in Boston, public parks, as I said previously. Anything that would be normally deemed a public forum, you are permitted to exercise your right to protest or demonstrate. Where can't you do this? And how can't you? You are not permitted to go onto private property. And once you encroach on private property, at that point, the private property owner sets the rules as to what you can and cannot do. And if they tell you to get off and leave their property, they can. And if you do not, at that point, you are violating criminal law. You are a trespasser. You are no longer a demonstrator. A lot of the the local protests that occurred after the election were sort of snapshot kind of things. They were very quickly planned and things of that nature. What if you want to do something larger? Do you need some type of a permit to do what you're doing? The answer usually is not usually. There are certain types of events that require you to have a permit, but these are usually much larger events. A huge march that you don't plan on keeping on the sidewalk, but that's going down the street. Anything that might get into the area of blocking off roads, you want to have a permit, or they're going to make you get a permit. Anything where you are using some sort of a large amplification device, they're going to want you to have a permit. Certain, as I said before, public parks are permitted, but you may also run into problems with certain designated public parks or plazas or things of that nature that, because of the nature of it, you're going to require a permit to be there. Many of the permit procedures require you to do this 3-4 weeks in advance sometimes, but this advance notice requirement, they can't use this advance notice requirement to prevent your rally strictly because of what it is that you're saying. And if this is a rally that is in relation to a sudden event or an unforeseeable event or something that happens very quickly, the police or the government cannot use this requirement to restrict your ability to speak. Many of these permit requirements, they give a lot of discretion to the police or to local city officials as far as the conditions that they can impose on what you're doing. They can restrict the route by which you are going to take. They can direct you. They can discuss or limit the loudness of your amplification device because there are public ordinances related to sound. The key here always is they cannot discriminate or restrict you because of what you are saying. Content is protected. The context in which you exercise that content may run you into problems. All right. So in terms of modifying the level or loudness of your speech or where you are directing a particular march or something of that nature, law enforcement and the government is allowed to step in and do something there, but they cannot do it strictly because of what you're saying. A permit cannot be denied to you because the event is considered controversial or because the views being expressed by those people that are protesting are in fact unpopular views. And unpopular depends on the viewer, depends on the listener. There are specific issues that you might run into. If you don't have a permit, where can you go? Where can you march? Where can you protest? If it's a moving kind of demonstration, a moving protest, you have to stay on the sidewalk. You have to obey any local traffic rules. You can't block up intersections with people. These types of activities are protected, even if you don't have a permit. Stay on the sidewalk. Don't block traffic. Continue to move. You would probably, in certain situations, depending on the volume of people that you have, you might be restricted by law enforcement to allow for enough space on the sidewalk for the normal traffic, people who would normally be on that road, to pass here and there. But you cannot, as a result of your march, and this is something that's coming up in some of these demonstrations, you cannot maliciously obstruct or detain passersby. You can't get in their way to make them hear your message. If they don't want to hear your message, they're entitled to go, and you can't stop them from going. And if you do, at that point, you are treading in that other area of no longer being a safe protester. You are now being someone who is obstructing traffic. And the key here is do not give law enforcement anything that they can use to stymie your protest. Think of that always. That has to be the question in your mind. Am I doing something here that the police could look at and use to stop me from speaking, because then it's no longer an issue of content, it's an issue of context, and you have to be careful with that. If you are out marching, if you are on the streets, if you are demonstrating, you are permitted to approach pedestrians on public areas, and you can give them leaflets, you can give them handouts, you can give them pamphlets, you can solicit donations even without a permit. You can, in certain parks, in certain areas, you can set up tables. You can lay out areas on sidewalks or near sidewalks for purposes of distributing this information, or to hand out pamphlets or signs or something of that nature. The key there again is, as I just discussed, you cannot impede normal traffic. So as long as you leave space on the sidewalk or in that plaza for people to pass, you should be fine. These types of activities, distributing leaflets, is the very essence of First Amendment demonstration and protest. You are allowed to do these free speech activities as long as entrances to buildings and passersby are not physically detained, and buildings that essential driveways for usually this happens with City Hall or other types of courthouses maybe. If you are blocking the entrance, or if you are blocking a driveway where there's normal traffic that's coming, you have to stop that, all right? But it has to be something that is engaged in legally. Do you have a right to picket, right? And some of this, you want to get out, and I see people out in front of Trump Towers, and they're picketing, and people in front of certain buildings, and they're picketing. You are permitted to picket, and you do not have to get a permit to do it. But just like I discussed previously, it has to be done in an orderly fashion, non-disruptive to normal traffic, so that pedestrians can continue to pass by, and as long as building entrances aren't blocked. Someone asked me a while ago, can they charge you to exercise your free speech rights? To an extent, depending on the permit, yes, they can. If you're going for one of these larger marches or larger demonstrations, and they're requiring you to get a permit to do it, they can have an application fee. They can make you even put down a security deposit for cleaning up afterwards. If you're passing out a bunch of papers and they want you to clean up the garbage, that's something that they can do. Overtime police, they might even hit you for that. The key there is this. If the costs to you that they're trying to impose is greater than normal because, again, of the message, they can't restrict your content. If they're going to attempt to punish content by imposing these fees that they might not impose otherwise, at that point you're butting into a constitutional issue. But as long as you are peaceful, there's not an issue. It's when the crowd becomes hostile. It's when they have to throw police into the mix to keep sides apart, say, or to maintain general order in a potentially violent circumstance. At that point, you've crossed the line. We keep talking about this line, and sad to say, it is a movable line. It is contextual. It depends on the officer that's there. If it's too large a burden, however, if the financial aspect of the burden is too much, at that point, you run into a constitutional issue. If, again, it is based on what you're saying, the content of your speech, not the context, at that point, you're running into constitutional issues. Anything that, if they're allowing speech from one group and not for another, again, that's a content restriction, and that is not allowable. There are some times where if you are just not a specifically organized group per se, and they're trying to impose some sort of financial burden on you for making the speech that you're making, or engaging in the demonstration or protest that you are in, courts can step in if necessary, and keep that from happening. They can't necessarily they can't make you pay for your right to speak. Another issue that does come up, and it has come up not just recently, but in the past. If you are out there demonstrating And all of a sudden, either because you've planned this demonstration and you post on Facebook or other social media that we're going to be gathering at City Hall Plaza in Boston, or we're going to be gathering in front of the Norwood Town Hall, or wherever it is, and you post that out there. If it's public, then you are potentially inviting counter-protesters to appear. What rights do they have? The same as yours. They can be there. They are permitted to speak. They are permitted to shout you down the same way you would be permitted to shout them down. They have the right to stand on one corner and speak at the top of their lungs against something that you on the other corner would speak with your own lungs to promote. They're allowed. But they are under the same restrictions as you are. So they can come, they can counter-protest, but they cannot physically disrupt the protest. They cannot come in and physically move you out. They are not somehow deputized by the fact that they are counter-protesting. They have to abide by the same rules. Same as you are not allowed to physically impose yourself on pedestrians, they are not allowed to physically impose themselves on you. They have the right to be present. They have the right to voice their opinions. They have the right to stand, and they have the right to hold up signs the same way you do. They have the right to voice their displeasure the same way you do. They have to abide by the same rules. All right? The police are permitted to step in, and they are going to break up any antagonism. I have a question here. So what do you do if you plan to have a peaceful protest and people come to peacefully protest with you and they start to become unruly? In essence, what you're asking is, how responsible are you for people in your own group? At that point, and I've argued this before, every political ideology, every political movement, every speech group, every demonstration has to bear some responsibility for the fringes. So if you go in and you have people there who are going to become unruly, you yourself have to be responsible for monitoring them. And if you cannot monitor your own people, then you have to exercise some discretion with them to get them out. All right? And if your own people are not acting right and they're not representing your group the way you want them to, honestly, get the police to move them out. Because they're not with you. They're not helping move the ball forward. And that's hopefully what a peaceful protest does. You are expressing your views. You want them heard. And if somebody is out there trying to do something to diminish what you're saying by how they act as part of your group. You saw certain protests that took place over the past couple of days, and there was a video of some woman who was advocating violence. That can be used against you. It minimizes your ability to speak. It minimizes the seriousness with which of the message that you're attempting to get across. So you want to have that taken care of. And if she or any person like that is there, you need to get them out. Whatever, don't quote Malcolm X, by any means necessary, but certainly by any legal means necessary. So if there are counter-protesters, the police are permitted to step in and interject themselves to keep antagonistic groups, 2, 3, or more, however it is. You want them, they're going to be allowed to step in. But they can segregate you into a general vicinity. Does it matter if other groups are in the same place at the same time, other speech activities? The government can't discriminate, like I talked about all the way back. The government can't discriminate against activities because of the controversial content of the message. That's always the key when you're talking about the First Amendment. Content cannot be restricted in pretty much any circumstance whatsoever, barring the certain things that are not protected: libel, slander, obscenity, but not like obscenity with vulgarities, but obscenity like pornography, yelling, fire in a crowded theater, all of those classics that are not protected. They cannot restrict you because of the controversial nature of your speech. I have a question. Can protesters legally enter a construction work zone, and can they be held liable for any injuries that occur to workers as a result of the intrusion? If it, as I talked about at the beginning of the talk, and I don't know, I'm a neophyte with this Facebook Live. I don't know if people can wind it back or something, and hopefully it gets saved and can be replayed. I'm really not sure, and I hope that's the case. But in a public area, protesters and demonstrators are allowed to be there. If it is a private area, enclosed private area, then the owner or director of that private area can restrict who can be there and who can't. So if that's the case, you can then move them out or call police or law enforcement to have them come in and move them out. The private owner sets the rules. All right? Sets the rules. So if they want them out, the police will come and get them out. No different than any other trespasser. So again, the government cannot discriminate against your free speech, protest, demonstration activities because of the content of the message, regardless of how controversial. They cannot stop you from speaking. If there was a group that protested there 2 days before and now you're there again, just because it was a similar event doesn't mean that they have the right to stop you. There's nothing there. It's Veterans Day today, so if there were a Veterans Day parade or something of that nature, and they permitted that Veterans Day parade to occur, and then you come in to for whatever reason you would want to do this, which hopefully is not one, that you would counter-protest a Veterans Day parade, A, good luck, but B, if there is some way that they're stopping you from doing that, they are restricting the content of your speech. They cannot do that. If there's one thing you take from this ChrisChat, it's content cannot be restricted by the government, but the way you exercise that content can. So First Amendment talks about peaceable protests. You're allowed to peaceably assemble. When you breach the peace, then you give law enforcement or the government a window in which to crawl through to get you out of there. I've been talking more about protests and things of that nature, but there are other types of free speech activity. You know, FSAs is the term that we use. First Amendment covers all kinds of communication. If you want to go out and have a music festival or a theater performance, or to show a film or a dance, something like that, that covers it. The Constitution covers actions that are symbolic in nature. If you, let's see, candlelight vigils. You know, nobody's speaking necessarily at a candlelight vigil. Is that covered by the First Amendment, even though it's not speech? The answer is yes, because you can nod at somebody, and that could mean, you know, go take them out back and beat the heck out of them, but that's not spoken. You know, so if it's symbolic expression is also covered by the First Amendment. So that would be people going out and wearing black hoods or white hoods in certain circumstances, but they're allowed to stand and look as they look, as long as they are abiding by the time, place, and manner restrictions that are put in place normally. They have to abide by the law the same way you do. Symbolic acts and other types of protests or civil disobedience actions of some type, if they involve what the police deem to be and what may in fact be illegal contact or illegal conduct, these things fall outside the realm of what is protected by the Constitution. Speech is protected, but if you go beyond speech to engage in physical conduct of any type that might violate some other area of the law, you have now crossed beyond expression, which is protected, and entered into an area that is potentially sanctionable by the law. You don't want to give people that window. If you're out on a sidewalk protesting, fine. If you are sitting in the middle of the road and stopping traffic, then you've got a problem. All right? You may, in fact, be expressing a political opinion. You may, in fact, be expressing your political opinion by saying nothing and sitting in the middle of the road. Maybe you've chained yourself to a barrel. We saw things like that in Boston during the Occupy movement and things of that nature. That is it might be symbolic expression to you, but at that point you are violating other laws. And that the police will have the ability to come in and stop you. So it may be an opinion, and it may be expression, but it is criminally sanctionable. And so you want to step away from those type of areas. If you are, in fact, peaceably protesting, if in fact you are out there abiding by all of the rules, and the police still want to stifle the protest or do something to you, and here's advice that you would not normally get from me, speaking as a criminal defense attorney, but here's what I'm going to tell you in terms of your right to demonstrate as a protester. It is not going to do you any good to get in the face of a street-level police officer. It's really not. And in fact, that action by you, although again, you might believe that that is part of your right to protest, that action by you can then be used as obstruction of justice. It could be seen as threatening a police officer. It could be seen as disorderly conduct. You don't want to give law enforcement a reason to stifle the content of your speech because of your conduct in exercising that content. So if you are arguing, if you find yourself faced off against a law enforcement, somebody from law enforcement, a sheriff, police officer, whomever it is, it doesn't do you any good to argue. What you do, ask to speak with a desk sergeant, ask to speak with a watch commander, ask to speak with a supervising officer on site. There may usually be one, especially if it's a large enough group. They're going to assign somebody to it. Peacefully tell them that you are not disrupting activities, that you are not disrupting anybody else's activity. And remind them that the First Amendment protects what you are doing, assuming that you are, in fact, operating within the bounds of the law. Remind them that if you don't obey the officer, you could be arrested. They take you from the scene, they cuff you, they do the whole thing, all right? It is unlikely that you would be convicted as a result, but the short-term effect of you stepping in their way is your message gets stifled. So you might be arrested, you might be taken from the scene, you will be brought in front of a judge at some point that day or the next day. But if the court at that point looks at that situation and determines that you are exercising your First Amendment rights and that your rights, in fact, were violated by that officer, it is unlikely that you would be convicted. But again, it depends on what you did to do so. All right? Question. What if the land that you are protesting on is disputed? What rights do protesters have in the pipeline case in the Dakotas where Native Americans claim the land? Are the protesters trespassing on a private construction site or defending land that is not private? It's a definitional question. It's if the land itself, it's going to wind up being an argument as to whether it's private. That's going to wind up in the hands of a judge, quite frankly. At that point, law enforcement steps in and they quell the speech temporarily, but now you're talking about optics, and the optics of law enforcement moving in and moving these people out is tremendously damaging. I have a question here. It's not related to the topic. I'll go ahead and answer it, but because it's here and I'm here. Chris, this is the subject coming up a lot lately. What is the impact of President Trump having the power to appoint a Scalia style justice to the Supreme Court. I'll tell you right now, and I've written this before, and I'll repeat it again. Justice Scalia was part of a four-person block on the Supreme Court that, was, for want of a better term, conservative justices. At the time that he was on the court was pretty steadily at four conceivably liberal judges, four conservative judges, and as I've written before, and I'll repeat it again, the most powerful person in American jurisprudence right now is Justice Anthony Kennedy, because he is the swing. He is considered mostly a conservative and falls on the conservative side. However, he has written some of the more famed liberal opinions, so-called liberal opinions on the court. Very pro. He wrote the Obergefell decision. He was the architect with the court in that. So it's not putting a new conservative in that seat simply reinstates the balance that existed prior to Scalia dying in February. It creates a 4-4-1 situation. People should be not as worried about this and that situation happening as the next 2 or 3 potential seats to come up. This seat is not the one that people should be worried about. Folks on the right were worried about it because it could have tipped the balance. If you put another conservative in that seat, you have simply reinstated the balance. What you have to worry about now, if you are worried about how the court moves going forward, you have to worry about Justice Bader Ginsburg, who is in her early 80s. You have to worry about, and is considered a lion liberal on Lion for my conservative friends. She's a liberal lion on one side. You have Justice Breyer, who tips to the left a little bit, but has gone to the right on certain criminal justice issues. But Justice Breyer is 78. Justice Bader Ginsburg, I believe, is 83. And you also have to worry about Justice Kennedy, who is also in his early 80s. This sitting president, and whomever the president would have been as a result of this election, could conceivably have the chance to tip the balance. So putting someone, a conservative, in Scalia's chair simply reinstates what already existed at the time he died. The issue then becomes, if Ginsburg passes or if Breyer retires, whomever is in the Oval Office at that point has the ability to put somebody else on, for want of a better term, the right side of the aisle. And now you no longer have the balance that has existed in the court for the past 15 years. You potentially have an imbalance. And it's that point that you have to worry about in terms of what could result as far as the court is concerned. So this chair, I'm not so terribly concerned about it. You could be, but not terribly concerned about this result. The real issue comes when one of those other 3, or any of the other, if anyone from the left side of the aisle goes, and the president sitting is a person who is considered conservative, if they put a justice in one of those seats, you no longer have a 4-4-1 in the middle balance. You have a 5-3-1, and that is really what tips things. The greatest legacy sometimes that a president has is not the library that they build for them. The legacy is that a president has 1 or 2 terms in office, 4 or 8 years, but if they put a justice into a seat, the justice is there for life or until they decide to retire. And so if you put a 50-year-old or 45 or whatever year old justice in that chair, long after the president has left the White House, you have potentially influenced American jurisprudence and law for decades to come. That is the true legacy when you're talking about the Supreme Court and presidents. And frankly, I think having the nuclear codes and being the commander-in-chief is the biggest power that a president have. But long-term and legacy-wise, it's the power to select justices, because that goes long, long into the future. question here. Are there any safety nets available in case the balance is skewed one way or the other? If you're talking about the balance in the court, the answer, frankly, is no. If the balance of the court shifts to one side or the other, that's what you have. The Supreme Court is not final because they're right, but they are right because they are final. They are the last word in what the Constitution says. So if you have justices there that are a majority to one side or another, you wait for another president to come by. And that's really what it takes. People, if you ask certain folks on the right side of the aisle about the Warren Court, they'll tell you that was a disaster. Back in the 60s when Earl Warren and a majority, liberal majority, ran the court at that point, and from that liberal majority, we wound up with Miranda versus Arizona. We wound up with Mapp versus Ohio. We wound up with Jacobellis. We wound up with all of the free speech cases regarding imminent lawless action and things of that nature. Brandenburg versus Ohio. All of these cases that came about in the 60s that opened up a lot of liberal avenues that people on the right said, well, hell, this is a nightmare. So it can happen. It has happened, but guess what? We weathered that storm, and courts over time can make changes. If you don't like, or if the legislature doesn't like what the court has done, then Congress steps in and passes a law. In 1990, the United States Supreme Court, with Justice Scalia writing, they struck down the ability of businesses to. They basically said at that point in Employment Division versus Smith that you could stop someone's religious freedom simply by, if as long as the law that they were using was equally applied across all. They stopped somebody from getting unemployment benefits because they used peyote, and peyote was illegal. It was an illegal drug, so they fired them and stopped them from getting unemployment. What happens there is the United States Supreme Court said as long as the law is applied generally across all groups and not specifically directed at a religious action, they're allowed to do it. What happened as a result of that? In 1990, when Scalia wrote that decision, a year after that, the Federal Religious Freedom Restoration Act was created, and now we've got 38 other states that also have their own RFRAs. So if they don't like what the court's going to do, they step in and fix it themselves with the legislature. And then, if the governor or the president signs something into law, then the court gets a chance to look at it again. That's what happens. It's what we have. We have checks and balances. Why isn't President Obama currently allowed to select a justice? He is. He did. He put Merrick Garland up for the Senate, but the Senate has, under their advice and consent powers granted to them in Article 2 of the Constitution, they have the right to not put that person selected in front of the Senate for a hearing. They've been given that power. Could the president do what's called a recess appointment? In essence, what would have to happen there is the United States Supreme Court is 8-8 right now. There's an empty seat. The Senate or the Congress would have to be out of session for, I believe, a period of 7 consecutive days. At that point, the president could appoint someone on his own without the Senate having confirmed them. But as soon as the Senate comes back into session, they could, vote that person out. If you head down that road, it just becomes a circus. I mean, you might as well just put clown shoes and Shriners hats on everybody and put the whole government inside of the back of a midget car. That's just how it's going to work. So I have reached the end of my discussion about protest rights. If anybody, I'll leave it open for questions. If anybody's out there that still has questions about the rights of demonstrators and protesters under First Amendment, please write in and I'll try to answer them as quick as possible. But I'll leave things open for 5 minutes right now. This is, I hope it works for people. If it's something that people found enjoyable or educational, I would certainly do this in the future. and on other issues. Perhaps if you have other areas of the law that you want me to weigh in on and give you some primers on, I'd be happy to do that. But send me individual messages. If anybody here obviously knows what my Facebook page is, and you can always message me there, and I can take care of that for you. And perhaps this becomes a more regular thing. I'm very happy to be able to do these ChrisChats for you. So look, the law is a scary thing, but your need to know is so tremendously beneficial. So many of the questions that I get asked are because people think they know something, or they don't necessarily have the resources or the wherewithal to find out. If there's one thing that they taught me in law school, it's not what the law is, but how to find it when I don't. And so if there are questions that you have, that's what you're doing with me. If you don't know the answer, talk to someone who you have some degree of sense or sense that they know what the answer is, and perhaps they don't know, and they go look it up for you. But I'm happy to have done this. And if there are no other questions, I'm going to put this to bed. And thank you very much for tuning in, all of you folks who I have a question here. In the light of recent events, is there liability on the media in promoting protests? My answer to that would be no. In terms of promoting them and making them come, I would ask the questioner, are you talking about because the media said certain things which resulted in protests? Do they have responsibility? No. They have a First Amendment right. They're protected to express themselves, both under their right to express speech as well as the ability to, their freedom of the press. What they cannot do, what the press cannot do, is libel someone or slander them by means of their press credential. But pushing people to protest, they're permitted. They cannot, however, the restriction here is, and I'll say this, they cannot promote violent protests. You can't do it. That strictly falls under Brandenburg as an individual speaker, and if an entity did that as well, if they're inciting violence, then that speech can be restricted. If the speech that you are engaged in incites what under Brandenburg said was imminent lawless action, then you could be held responsible, and your speech content could be either restricted or punished. The case in Brandenburg dealt with a Ku Klux Klan leader who was talking about African Americans and talking about Jewish people and how certain things should be done and how they should be addressed by the public. And the police came in and stopped him under an Ohio law that talked about inciting violence and creating a clear and present danger. And what the Supreme Court said was, as long you can talk about what you want done until you're blue in the face, but until you actually tell someone, go to City Hall, drag the mayor out by his feet and hang him on the town square, and they're inciting this type of violence, that point you can stop them. But until then, you cannot. They're allowed to speak unless that speech breaches that or could create an imminently lawless action. So that's my response to that. If there are any other questions, I'll sit for a couple of more minutes and maybe some comes in. Hank, good to hear from you. It's been a long time. Congratulations on your son, by the way. Great basketball career. Hope he keeps it up. As I said, the idea here is to give information. It's better that you have it. If I have it to give, I'm always going to give it, and I'm always going to answer questions. So with that, I don't see any other questions coming in. If you do have them, you can private message me, and I'll hopefully get to them very quickly. But thank you all for tuning in, and thank you for the comments, and thank you for asking questions. And like I said, if you have other topics that you want me to weigh in on, send me a message, and I'll be happy to set up another ChrisChat when there's time. And again, Thank you so much. And no, Curbs, I am not doing this from the friggin' Olive Garden. That's never going to happen.